Recording in progress.
All rise. The Circuit Court of Cass County is now in session. The Honorable Mark A. Herman presiding.
Please be seated. Go on record on the court's sentencing docket on Friday, January 26th. First matter the court will call, file 22-10325 FC, file 22-10326 FC. People State of Michigan versus Craig Andrew Lawrence. Mr. Lawrence is present here in court today for sentencing, and his attorney, Robert Drake, is also present. On behalf of the prosecutor's office, Prosecutor Victor Fitz is here on behalf of the people. As indicated, this matter is on the court's docket for sentencing here today. I did receive the pre-sentence investigation report as well as the sentencing information reports that were prepared in reference to the homosexual conduct first-degree charges, and I had a chance to review those. I also did receive and review a Cass County Victim Assistance impact statement that was filed by Elaine Scala, and I had an opportunity to review all those documents. Let me just confirm with counsel if they had an opportunity to review those documents and if they have any additions or corrections.
None of the people have had that opportunity. We have no additions or corrections.
All right, and
Likewise, Your Honor, I've had an opportunity to go over the pre-sentence investigation, the letter from Ms. Scala. I had an opportunity to go to the jail and go over the same documents. I provided Mr. Lawrence a copy of the sentencing manual yesterday so that he could understand better the offense variables and PRVs. And I do have some objections to the scoring of the offense variables.
obviously there's no prior record,
Correct.
misdemeanor felony record, although PRV 7 was scored, no objection to that.
No objection to
Okay.
the PRV.
All right, we'll hear then the objections to the offense variables.
Your Honor, I think that offense variable 10 being scored at 15 is incorrect. When it comes to the agent's description of the touching and penetrating, that's part and parcel of the sentencing offense, and I don't believe that that should be counted towards predatory conduct. Predatory conduct is post-offense conduct. The remainder of what the agent described is all pre-offense conduct. I do not believe that that counts as predatory conduct under OB 10. In the manual, it has a definition of predatory conduct, and it states that the predatory conduct is post and pre-offense conduct. But again, the pre-offense conduct is all part and parcel of the sentencing effects, and I don't think it should be properly scored at 15.
Is your position that it should be scored at 10 because it is the accused or domestic relationship?
Correct, Your Honor. I think that 10 would be the more appropriate scoring.
Prosecutor Fitz, any position regarding the scoring of the OB 10?
Judge, I think it's properly scored. There certainly was, penetration obviously is the primary convictions for this defendant on multiple counts. We have a number of instances of predator grooming behavior, predatory behavior that included with Madeline at age 5 and 6, going into the bathroom, watching her take a bath, staring at her in a disturbing fashion, then later on touching her, at age 7 and 8, and all those things led up to the ultimate criminal offense of at age 9 of beginning to penetrate her. Also, you have grooming and predatory behavior by him having the girls watch, or at least Serena watching pornography, those type of things, prior to him ultimately molesting her in a manner that resulted in his convictions. I think other grooming and predatory behavior was scaring these young women. Obviously, there's certainly a size disparity between them, but then also telling them that if they, both before and certainly after, that if they talk to anybody about this activity, that he's going to hurt their mother, and those type of threats. So, I think there's an abundance of predatory behavior, grooming behavior that would allow a scoring of 15 in this matter.
Let me ask you, why isn't that part of the offense itself? When you
Well,
say the youth, when I look at the scoring on OB 10 points, it does talk about exploited a victim's youth or a domestic relationship. Isn't that what we're talking here more? He exploited that relationship in doing those things, but not that was necessarily pre or post predatory conduct. I mean, obviously the offenses themselves are serious, but I think the scoring of the other OBs takes into account the conduct itself that you've stated, as opposed to predatory behavior.
Well, Your Honor, again, and I do understand that, ages in and of itself, would allow for the scoring of 10 on this OB and so forth. But again, as indicated, we've got more than that. We've got, not only did he take advantage of their age and youthfulness, he did specific things to groom them, to prepare them to molest them. And that was, again, the things I mentioned, such as watching them in the bathroom, taking a bath, watching videos, that's not age dependent. These are separate acts.
No, but isn't that exploiting the domestic relationship? I mean, that to me, it wouldn't be like some neighbor doing these things or a babysitter doing some of these things. It appears to be more of a domestic relationship.
I understand the court's position on that, Your Honor, but I think that just because there happened to be a domestic situation, this could certainly happen if there was not a domestic situation as well. Visiting a neighbor, doing these things, or having a neighbor child come over for these type of things. So I understand the court's position, Your Honor. We just feel that 15 is appropriate.
All right, we'll note your position for the record, Prosecutor Fitz, but I think on OB 10, I do agree with your position, Attorney Drake. I think OB 10 is more properly scored at 10 points as opposed to 15, so I'll make that adjustment in the scoring. Any other?
Yes, Your Honor. And OB 13, I think, is improperly scored at 50 points. I don't believe that there's a preponderance of evidence of the number of instances. The testimony at trial certainly led to conviction on, in this case, over 20 of the counts, but there was not all the counts did the jury find Mr. Lawrence guilty of. And there still needs to be a preponderance of evidence to show that the other events happened, and I don't think that just the mere reporting of other instances is a preponderance of evidence given the testimony at trial, so I don't believe that OB 13 is properly scored at 50.
Prosecutor Fitz?
Judge, again, the jury believed both of these victims in this matter, and the testimony was clear from one of them that the molestations, the penetrations were over 100 in number, and the jury obviously in this situation found these young women believable. I believe the court also had a chance to hear their testimony and judge their credibility, and I think that they certainly established by preponderance of the evidence that this occurred around 100 times or more.
I think having heard the testimony, I think the court can preponderate under OB 13 that there were involved in this situation within a 5-year period, which is required under OB 13, that there were at least 3 or more sexual penetrations against a person or persons less than 13 years of age. And I believe that the scoring of OB 13 at 50 points is proper, so I'll note your objection, Attorney Drake, for the record, but we'll go ahead from the court standpoint, leave OB 13 score at 50.
Thank you, Your Honor. My last objection is to OB 19. The conduct that they're using to score OB-19 at 25 points is not related to the sentencing offense at all. And although Walker certainly allows the court to consider post-offense conduct, there still has to be some sort of connection to the sentencing effect. There are charges pending for this conduct, and I think that it would be a different situation if he had tried to escape, or if he had, fought with the guards being transported back and forth, because those have some tie to the sentencing offense. But this conduct alone, according to the agent and according to the allegations, started in a dispute between another inmate and Mr. Lawrence that bubbled over into dispute, but it has no connecting tissue to the sentencing effect. And I do think that all of the offense variables need to have some of that connective tissue, whether it's post-offense conduct or not. So I think that OB-19 should be properly scored at 0, because with the exception of this conduct here that's described, he did not try to flee, he did not, resist arrest, he did not even leave his home, even though he had months between the time the allegations were first made aware to him and the time of his arrest. He didn't even quit his job, they arrested him at his job. So his conduct, in relation to these offenses, there's been nothing that I believe would be scorable under OB-19.
All right, what about, as far as 10 points? Obviously, during the investigation, they continued to deny, place blame on the wife in fabricating the story in this regard. So obviously, I look at that as more than maybe just a denial, so maybe 10 points.
Well,
I mean, and I understand your
yeah,
position as counsel.
that's certainly the court's, the court could certainly take that reading. I would, find that reading a little bit too vast. Again, the burden of proof is on the government here, and when somebody says, I didn't do it, and then they're asked by the police officer to speculate as to why would they do it if it hadn't happened, I don't think that it is an interference in the administration of justice for them to answer the police officer's questions with, well, I don't know, but here's, what I think. I made this argument at trial too. If you're asking Mr. Lawrence to get inside the head of people who are falsely accusing him of these events, he certainly can't read their minds. And if he's asked, he's going to speculate, just like anyone would, as to what are some motivations for this sort of conduct. So I hear what the court is saying, but I would just say that my position on that is that it was a mere denial. The follow-up question of why would they do it provokes a response that, is speculation on Mr. Lawrence's behalf, but it didn't interfere with the investigation, it didn't interfere with the administration of justice, and so I still think that even with that, it would be properly scored at 0.
Judge, the report writer indicated on page 2 the rationale for the scoring of 25 points, and I'll let the court consider that. But I'd also note that even if the court doesn't score it because of that rationale, I think that on OB-19 that 15 should be scored because the offender used force or the threat of force against another person to interfere with or attempt to interfere with the results and so forth, the administration of justice. As the court knows, again, in this case, the defendant told these young victims repeatedly that if they tell anybody about this, that he's going to hurt their mother. And certainly the purpose for that was so that he could continue unabated in his predatory behavior against them and not get caught and not have to suffer the consequences. So I think 15 is certainly properly scored. The court also, obviously, if the court didn't have the 15 to score, I think the 10 certainly would also be available for the court to score. The court has kind of placed already some of the rationale for that argument in its comments. This was a concocted version by the defendant of certain, getting money and so forth as being a motivation for the girls to lie. It was a story that he weaved, and that did have some interference with law enforcement. They had to check into those type of things, see if that in fact was the case, and it doesn't appear that is the case. But again, that diverted resources of the law enforcement to check into that as well. So.
Let me ask, when you say the threats, wasn't that pre-investigation? How would that have interfered with the investigation by the police? I don't know if there were any threats made subsequent or once the investigation started. I understand that, it's not uncommon in these cases as well to have, threats made to victims that they will harm, don't harm family, they don't harm animals, whatever the case may be. When we look at the interference with the administration of justice, are we looking at something that interferes with the investigation? Because in that scenario, if anyone ever makes a threat on a victim, in that regard, you could always say, well, it's at least 10 points because there's been some threat. I would think when I look at OB-19 that there has to be, it's got to be something that's involved in the investigation of the offense itself, and not something that just a victim or a defendant does, pre-offense.
Well, Your Honor, I think it is important to look at the wording of OB-19 because it doesn't use the term interference with the investigation. It talks about interference with the administration of justice, and it does not have as a prerequisite that it be something that was, when the investigation had started or when the formal charges have been brought, those type of things. It talks about the administration of justice. In this case, he did interfere with.
In that situation, then you would indicate then that any situation that kind of threatening the victim, that it would never be scored at 0, would always be scored at 10 as a bare minimum.
Your Honor, I can only speak to this instance, but in this instance, because I think every fact situation may be somewhat different, but in this instance, again, this allowed him to molest these girls for years, and certainly justice in this matter, the administration of justice, would have been the first time he did it, that they were brought to justice, that the girls would have had a chance, would have felt the courage to go and talk to their mother about this, and the mother, to take this, to law enforcement. But again, the girls delayed reporting on this for an extended period of time because of the fact that they were worried that their mom was going to be hurt by the defendant, because that's exactly what he said. And that, Your Honor, would be our position. That clearly interfered with the administration of justice.
Very great.
Well, Your Honor, I think that the court was correct in indicating that that was all prior to the police even being informed of it, so I don't know how it could interfere. So I think that that's an apt description, and again, I think that properly scored at 0.
All right, when I looked at it myself, I thought the scoring at 25 was inappropriate because it was that scoring at 25, which is on OB-19 dealing with the threatened security of premises. I think that totally has nothing to do with this offense itself. I believe that obviously there are pending charges in that matter, and I don't think that it has to, as you've indicated, it has to be tied so much to the underlying offense. I don't think the scoring is proper at 25 points. I think I'm going to score OB-19 at 10 points. Attorney Drake, understand your argument. When I look, it looks like when Mr. Lawrence was interviewed, he indicated obviously 2 things. Indicated to the police, not only was it just a denial, but then he indicated, I believe his wife was acting erratic because she was cheating on him with men at work, I think, which would have probably required some investigation into those things, further allegations further, as well as advising him to believe that the accusations stem from the fact that children would get money soon for the child ancestry. So I think there's enough scoring there that he did not just deny, but he did in fact lie, give some alternative theories that would have probably required additional investigation and followed by the police. So I'm going to go ahead and score OB-19 at 10 points as opposed to the 25. Attorney Drake, any additional?
No other objections, Your Honor.
Okay. When we look at the offense variables then, we've got 10 on OB4, 10 on OB10, 50 on OB13, 70, and OB19 at 10, so that would be 80. When I look at the Class A offense, originally, the original level was scored at 6. Looks like that reduces the OB level under the court's calculations to OB level 5, 80 points. And so when I look at the guideline range, that looks like it would reduce the guideline range from the scored 135 to 225 to 126 to 210. So I'll go ahead and make those changes as well. And obviously, we don't have the scoring of the lesser charges. I did obviously score them for sentencing purposes from the court standpoint, making those same corrections to the Class C offenses, which are the CSC second offenses. That would reduce the guidelines on those offenses to 19 to 38. With that then, Attorney Drake, did you have any other additions or corrections to any of the information in the report?
None, Your Honor.
All right. Mr. Lawrence, Attorney Drake indicated that he got you a copy of the report and you had a chance to review it. Is that correct?
Yes.
Okay. I'm going to give you an opportunity to address the court if you choose to allocute on your own behalf. You don't have to, but you'll have that opportunity. In reference to the information in the report, were there any factual discrepancies that you had? Obviously, children, education. When we look at all the background information, were there any additions or corrections that you wanted to make to the report?
Yeah, the report stated that the interviewer said that I had 3 daughters, but I have 2 daughters and 1 son.
Okay.
It
So
does state that.
all right, we'll go ahead then and make that correction and note that you do have 2 daughters and 1 son as opposed to 3 daughters. With that then, anything else you wanted to, before I give you the opportunity to allocate, any other corrections?
Yeah, there was misinformation about my work history, and
Okay,
about statements that I made.
okay, and the statements I understand. What about your work history?
It says that I was a small engine mechanic, but I was actually a heavy engine mechanic,
Okay.
a diesel engine mechanic. So there was a misunderstanding during the interview.
So when it says small engine repair, you would say that should be?
I was previously a small engine repair, but currently my latest employment was a diesel engine technician,
And would that have been with Osra?
at Osra Kubota.
Okay. And that was diesel, what did you say, diesel
Mechanic.
mechanic? Any other additions or corrections to the information in the report?
Yeah, I don't believe that some of those quotes were quoted exactly as I stated. There were statements outlined in there that were quotations,
Okay,
that I don't believe those are exactly the statements that I made.
okay, and I'll give you an opportunity to address that in allocution. We'll note for the record, actually indicated that you don't believe those statements were, accurate. We'll give you the opportunity to address that if you choose, okay? Anything further than you want to bring the court's attention on the report?
No.
All right. Prosecutor Fitz, then, before the court pronounces sentence, then we'll give you an opportunity at this point in time to address the court. And again, obviously, based on the nature of the offenses, I don't know if there are any victims here that care to make any statement to the court.
Judge, both the victims are in the courtroom along with their mother and supportive friends and family. They do not wish to give any statement here today. I'm just asking.
Okay, and we'll take comments from your office, then we'll hear from Attorney Brown. As I indicated, Mr. Lawrence, I will give you an opportunity if you choose to make a statement.
Thank you, Your Honor. Well, Your Honor, in this matter, the court and the jury were asked to perform the solemn responsibility of peering into the heart of darkness, and in this case, they certainly did just that. There was extreme darkness in what they saw, but I think, Your Honor, as the court also saw, and the jury's verdict reflected that the light of truth ultimately prevailed in this matter. The victims who testified were brave and resolute, and in addition to providing the facts which are providing justice for us in this case here today, I think, Your Honor, these young ladies, by testifying and providing that light of truth, have neutralized the danger of other young girls being victimized or molested by this defendant in the future. And molest and victimize these two young girls is certainly what the defendant did. The court heard testimony into the heart of darkness and into the predatory behavior of this man. There were two victims, as the court is aware. The first one, from ages 8 to 15, this defendant molested that young lady over 15 times, forcing himself on her, even when she was sick, and ultimately threw up on him when he was insisting upon sexual gratification from this young girl of tender age. The defendant told the victim, this particular victim, as well as the other victim, that if you tell other people, if you tell your mother about this, you're gonna get in trouble. And again, the threats were also made regarding the mother. The court also knows that in regard to the other victim, as we've talked about before, that he groomed her, again, at a very young age, from age 5 and 6, as she testified and as acknowledged and as indicated, that he would come in while she's taking a bath and stare at her in a disturbing fashion. Certainly, I think as the facts would support, as he was, satiating with the fact that he was going to also molest this young girl. He started the actual molestation at ages 7 and 8, touching her repeatedly, and then at 9, full-blown penetration. Also, with this young victim, when she was sick, that was one of the times that he utilized the opportunity to molest him. And again, this is extremely disturbing behavior. Again, so focused on his own perverse sexual gratification that he would molest young girls even when they were sick. Your Honor, and also the court heard again testimony about the fact that he told this young girl, and think about the terrifying aspect of this. Kids look at things in such a different way than what adults do, and we sometimes forget that as we get further and further into adulthood. They have a different perception of life and authority and people, and there's literally a size difference that is significant, that certainly contributes to this different vision of the world and what's happening. And he told this young girl that if you don't touch my penis, I'm going to hurt your mother. And again, certainly this put this girl in a terrible, untenable position, again, for the sexual gratification of this defendant. The court also knows that he has something the court can take into consideration, is that the defendant does have a pending assault, where he, again, in that situation, threatened to kill people as part of that, and certainly that's still pending, but the court has full authority to consider that. The recommendation, Your Honor, I think in this matter, the court is well aware of it, and I think it's appropriate, 40 years on the minimum. I think the court would be justified in going even higher if it decided to do so. And again, Your Honor, that's based upon the facts that the court heard. I don't think I need to elaborate further in regard to my allocution. The court heard abundant testimony through the multiple-day trial in this matter. The defendant needs justice here today. These young victims need justice today, Your Honor, and we'd ask that the court impose a sentence of at least 40 years in prison on the minimum in this matter. Thank you, Your Honor. And I apologize, Mr. Drake. One other thing I did want to say, Your Honor, that I neglected to say earlier, I also want to commend the two victims, and the mother in this case also, because again, as I talked about earlier, these were brave young girls, and because they came forward, we have justice here today. Thank you, Your Honor.
Well, Your Honor, obviously my client disagrees with the verdict, but we are here today and stuck with that verdict. I will keep my comments fairly contained to preserve a clean record for any appeal that Mr. Lawrence effectuates. I think that there are some things that stand out as of note in the PSI. The first is that in his compass scoring, with the exception of his family of origin, he scored unlikely in every single category in the compass narrative regarding residential instability, cognitive behavioral issues, unlikely in the criminal personality area. He has no prior criminal history at all, and I think that that supports what the compass scoring indicates as well. As I indicated, he still maintains that this did not happen. There's a 25-year mandatory minimum that by statute, is presumed to be a just, proportionate, and reasonable sentence. I think that given the lack of any sort of criminal history, given the change in scoring, and given the compass scoring and all of the factors that, would support a minimum sentence here, which would be that 25-year minimum sentence. And so I'd ask the court to sentence Mr. Lawrence at that 25 years.
Thank you. Mr. Lawrence, this is your opportunity to make any statement on your own behalf if you choose, anything that you want to say.
No.
All right, well, Mr. Lawrence, obviously you're before the court here today for sentencing, following a conviction by a jury on November 22nd of last year, sexually molesting your daughter, Serena Madeline, with acts that included anal sex, oral sex, anal digital penetration, touching of their buttocks, breasts, and vagina. With Serena, these acts, according to her, occurred over 100 times between approximately 2010 and 2017. With Madeline, as she was younger, the abuse alleged to have occurred. Some started somewhere around 2014 and continued through 2021. As a result of your actions, reported Madeline is in therapy, has repeatedly cut herself, and Serena has also been in counseling for well over the last few years herself. So, Mr. Lawrence, I know you claim that this was all some big scheme by your wife because she somehow wanted to get her hands on your children's per cap money. But to me, it's unbelievable that your two daughters would come into this courtroom and testify the way they did against you if you were the type of father that you would like us all to believe that you are. Your daughter's testimony in court's opinion was not only credible, but I saw nothing from either of them to lead me to believe it was concocted in any way. But we're not here to debate that issue here today. The jury heard the testimony, they heard your position, and the jury convicted you of the charges that you'll be sentenced here today on. And so accordingly, what the court is going to do, as Attorney Drake indicated, the court has recalculated your guidelines. Again, with the recalculation, those guidelines would even be below Attorney Drake, the 25-year minimum. And I think even as originally calculated, they were still below the 25-year minimum. So what I'm going to do in this matter, Mr. Lawrence, on the counts of 1 through 8 charges of criminal sexual conduct in first degree in file 22-10325 FC. It will be the sentence court to be committed to the Michigan Department of Corrections to serve a term of incarceration in state's prison for not less than 25 years to a maximum term not to exceed 40 years with credit for 492 days already served. In addition, in that matter, you'll pay $68 in minimum state costs on each count, court costs of $500, the court deems reasonable based on the average cost of prosecuting a case here in the county. We're going to order you to pay a crime victim rights assessment in that file of $130. Court will also order you to pay attorney fees in the amount of $350 to partially reimburse the cost of providing legal assistance in this matter. You'll also be sentenced to lifetime electronic monitoring as required by statute. AIDS and STD testing, complies with any DNA testing, pay the associated $60 fee. On the counts 9 through 11 in that file of criminal sexual conduct in the second degree, it will be the sentence court you committed to the Michigan Department of Corrections to serve a term of incarceration in the state's prisons of not less than 2 years to a maximum not to exceed 15 years with credit for 492 days already served. In addition, you'll pay $68 in minimum state costs on each count. As further required in those charges, you'll be required to be placed on lifetime electronic monitoring as well upon your release from incarceration. In file 22-10326 FC on the count 1 charge of criminal sexual conduct in the first degree, will be the sentence court you committed to Michigan Department of Corrections to serve a term of incarceration in state prison for a term not less than 25 years to a maximum term not to exceed 40 years with credit for 492 days already served. In addition, you shall pay $68 in minimum state costs on that count and a crime victim rights assessment of $130. And again, as required by statute, you shall be sentenced to lifetime electronic monitoring as required by law and comply with any AIDS, STG testing, and comply with DNA testing. In that file, on counts 2 through 5 of criminal sexual conduct in the second degree, the sentence court indicated Michigan Department of Corrections to serve term incarceration in state's prison of not less than 2 years to a maximum term not to exceed 15 years with credit for 492 days already served. In addition, on those counts, you'll pay $68 in minimum state costs on each count. And again, on those matters, you will also be placed on lifetime electronic monitoring upon your release from incarceration. You shall also comply with DNA testing. There was no restitution requested in this matter by the prosecutor's office, so none is ordered at this time. Sentences in both files will run concurrently with each other. Mr. Lawrence, I will advise you do have the right to appeal your sentence or conviction. It's here today. I'm going to have the bailiff deputy there provide you with notice of appellate right to review. If you do wish to file an application for leave to appeal, you can do so. And if you're financially able to retain an attorney and wanted to have an attorney appointed to represent you in this matter, fill out one of those forms. You'll receive 2 copies of that form. Return one of those copies to the court completely filled out. The court will review that. If you do qualify for the appointment of counsel at public expense, the court will appoint counsel. Just so that you're aware, any request for an attorney to assist you in your appeal should be made within 42 days of today's date. Thank you, sir. Prosecutor Fitz, anything further in this matter?
No, Your Honor.
Attorney Drake, anything further?
Nothing further, Your Honor.
Mr. Lawrence, do you have any questions for the court before we adjourn your case?
No.
We'll go ahead and remand the defendant back to the custody of the Cass County Sheriff to be committed to the Michigan Department of Corrections to serve the balance of his sentence. Mr. Drake, do we have Mr. Young? as
Yes,
well?
he's back.
All
He was in custody. Jail brought him over.
right.